I am Alan Barr. I'm a partner in Brodies private client practice area. I have been for many years. I'm also a lecturer at Edinburgh University. Many of you I know who are coming to this have seen me before and have been lectured at by me. One of the nice things about doing this was for the first time in weeks, I've been able to get formal and get into my moderately trademark suit and ridiculous tie. I've selected a particularly suitable tie to brighten everybody's morning on what would otherwise be no doubt a dull day. The subject today, and we'll now make that formal start, is wills and powers of attorney in the strange times in which we live. But I want actually to start by moving back a bit. Both wills and powers of attorney have always been important, regardless of our current circumstances. And without being either morbid or insensitive, I hope, the current crisis has simply focused, or will focus, the minds of ourselves as individuals and clients, if we are working in law or analogous areas of clients, on this vital part of what I will call life planning. Not estate planning, but life planning, because it's so much broader than dealing with the financial or property aspects of what people need to do. People should be considering these matters, wills and powers of attorney, not because they fear that it might become more necessary than they once thought, but simply because for their family and otherwise, it is the right thing to do. And I know it sounds a kind of trite phrase, but it's really important. It's one of these other areas where it is the right thing to do. And isolation, whether isolating really alone or with one's family, might just give people the necessary time to think about, consider this, and about how to do it properly. So making a will and or a power of attorney, or updating an old one to take account of changed circumstances, is a really, really positive step to take. It's positive for the individual concerned. It's also the right thing to do in a slightly more negative way, because the alternatives are frankly not very palatable. Dying without a will leaves those coming after you with one more worry to sort out, and every possibility that what you own will not end up where you want it to go. To take a prime example, if there's a wife or a husband or a civil partner, they may get less or indeed more than you thought they would. There's a well-known kind of pub law myth that if somebody dies without a will, but they're married or have got a civil partner, well, the partner will inherit everything. Well, that's not true. And indeed, the extent to which that is not true depends very much on their circumstances. It might be true in some circumstances, but it's certainly not the case in all circumstances. And moving beyond that to people who are in relationships that are not formalized, they haven't got as far as becoming wives or husbands or civil partners, but have been living together for a while, perhaps with children, then they might end up, your partner in that circumstance might end up with literally nothing. And if they end up getting something, then it will come after potentially a fight as to what they can get, and a great deal of trouble and expense in these circumstances. So there we are, the most common living circumstances throughout Scotland and the UK of people living in couples, and they, as much as anybody, more than many, need wills as much as anything else. As for powers of attorney, the alternative to not having one, should you become incapable of managing your own affairs, can be properly bleak. And in the case of the kind of next law down the line, that of guardianship, potentially extremely expensive as well. So if you have somebody in mind who can and will look after things as you would want, it is an excellent insurance policy. It is better than many insurances because, or it does, or it can only come into effect when and to the extent that you need it. The grantor, while capable, can remain in complete control, and while capable, can change the person that he wants to look after things, can remove that person entirely. And indeed, that's not just a matter of trite assertion, it's part of the law, that the person who grants the power of attorney, to the extent that they can, remains in control. But in the meantime, then the person with the power of attorney can operate it and can deal with things that the grantor might not be able to do. And it has occurred to me that just looking at things, our Prime Minister is a prime example of somebody for whom both a will and a power of attorney, before he was struck down by the virus, I very much hope that such arrangements were in place. Powers of attorney, I've never had one stretch to running the country, and I suspect that there might be doubts as to whether it could go that far, but a power of attorney would have been useful for personal things. As for wills in Mr. Johnson's personal circumstances, these are extremely complicated. That's probably as much as we know. They're about to get even more complicated, but he is again a prime example, as he's been in so much of this crisis, of the need for things that you might not otherwise think is going to affect you. So, Mr. Johnson, I hope that now you're out of so much trouble that you give further thought to your own will and indeed power of attorney as soon as possible. But the main subject then of today is, can you actually do this from lockdown, however lockdown is affecting you? And the perhaps surprising answer, given what seems to be the intensely personal needs attached to making a will or a power of attorney, is almost certainly yes. And that affirmative answer might come as a surprise to you, or indeed to those close to you. So let's look at this in a little more detail. What about getting instructions to draw up the document that you want? Well, what has to be done there might depend on whether the client has an existing contact with a solicitor, and if so, whether the client has access to any form of video contact, like what we're doing now, or otherwise, one of the many other video phone facilities that are available now. If both of these are in place, then frankly, things are not too much different from how they've always been. If the client is known to the solicitor, then instructions can be given in any normal way. And that can involve writing, whether by email or by snail mail, forms completed, sent electronically, or again by snail mail. There may be a bit of a warning about there in that surface mail is perhaps not quite as it was, although my current experience is that it's working pretty well at the moment. And taking our own firm as an example, we have mail coming in every day, being checked every day, where necessary being picked up and acted upon every day, or certainly within a few days. It may take a little bit longer to get there, but it is still working and continue to do so. So, if instructions are received or attempted by an existing client, then there's little difficulty in preparing a will. And I'll come back to what happens next just in a minute. What if it's somebody who's never got round to doing anything about this, who doesn't have a solicitor and may want to do this now for the very first time? Well, in that circumstance, then a meeting can take place over video conferencing facilities. But you'll be unsurprised to hear there are still requirements on the solicitor to ensure that they're satisfied that the person wishing to make a will has capacity, is able to actually make a will, is not being pushed into doing it. We call it undue influence into whatever is to be written down, and is not being got round in various ways that we see all too commonly in certain circumstances. It's also necessary to try and identify the person who you are accepting instructions from. But again, most of that can be done by video matters, with documents being held up to the screen, and we've got more and more used to dealing with this, to looking at documents over the screen, to looking at passports and photographs for ID, a photograph from a photograph as it were, but it's enough to get us over these hurdles. So if you can get, and most of the time we can get to the position of receiving instructions, a will or an alteration to a will, technical terms of codicil, can be prepared swiftly, very swiftly indeed if necessary. That can then be sent to the client, either again electronically or by surface mail, depending on the facilities available to the client. And again, depending perhaps on whether there is video facility available, but this time more dependent on whether the client has a suitable printer available. And it doesn't have to be able to produce kind of embossed or documents that are capable of illumination. It just needs to be able to print out clearly. The solicitor involved can and should give instructions as to how the printed out version should look, because there are certain rules about that as to what has to be on particularly the last page, but generally it can be printed out. If there's no printing facilities, then the solicitor can print it out themselves and send it by any physical means that they can. So we can readily get to the position where the client is in a position to have a will or alteration to a will signed. And at this point, we must stress something. I must stress something really, really important. In order for it to be effective in Scots law, all that is required is for the client to sign the end of the document. Ideally, they should also sign at the end of each page if there is more than one page, but technically one normal signature at the end of the document is all that's required. A normal signature technically again demands clear and able to be read last name and either first name and initials or a combination of them, rather than just squiggles, though squiggles have been accepted in the past. But the clear thing is that that normal signature at the end of the document is generally enough to get you over the hurdle of having a valid document. The bit at the end is important. It's only things above your signature that count for these purposes. Very few people, in fact, literally one person is allowed to do what's called superscribe rather than subscribe. That's the Queen. She starts things by signing rather than ends them by signing. I haven't made a will for the Queen recently, but I hope that her instructions are up to date and her will from whatever she is isolating at the moment is clearly enforced. So a will does not, therefore, absolutely require to have a witness. And a will signed but without a witness can be sorted out, acted upon, dealt with after the client's death. Though it is very much worth saying, there are extra procedures involved. It will be a bit more expensive. There'll be a bit more time and trouble in, as it were, converting what is a perfectly valid will into one that can be fully acted upon. But again, I stress the point that a clear signature at the end of a document is all that is required. What if we want to go further to get a witness will, to get a witness actually in place? Well, again, generally speaking, we can do so now. The client may have a witness available in his family isolation, although there in particular great care is required because a witness requires to be an independent person who does not benefit from the will in question. And that, of course, is exactly the situation which is likely to rule out family members with whom the client is in isolation. That is, spouses, civil partners, children, adult children, or young children who may well benefit under the will. They are not, as it were, eligible to be witnesses. But to take another example, a witness does not need to be close physically to the client, to the person signing any document. For example, and we've already had examples of this, seeing somebody sign through a window is perfectly possible, although I should warn, the need for the witness then to sign the same document, same bit of paper, may cause unnecessary worry about transmission of virus on the document itself. So it's not particularly to be encouraged, but it is something that can be done, again, in certain circumstances. The real additional possibility here for clients with video facilities is video witnessing, and it's certainly desirable if it is available. It has recently been confirmed, possible to witness the signature of a client by video. The person seeing remotely must see the document being signed and the client signing, and if it's a will, then signing on each and every page. It also gives them an opportunity to examine the document actually being signed, to check that it is the thing that has been sent out and it's in its complete form, whether that sending out has been electronically or by surface mail, so that the person witnessing can also check the document at that time. So what happens is that the witness, might be the solicitor, might be somebody in the solicitor's firm or family, if the solicitor himself or herself is connected, then sees the person signing and records in one way or another that they have done so. What happens then is that the will, which is perfectly valid after it's been signed, even without the witness's signature, can then be sent back, and details of the signature can be added at that point. That might be after restrictions have lifted entirely, or it might be more immediately, depending really on what the person wishes to do, whether they wish to keep the will or whether they wish to, as it were, entrust it to the post at that time. It does, however, to complete the process, need to be the original document, not merely a scan of it at that point. So what we have at the end of that is a complete and fully formalized will. once the witness does get it back and completes these details, and the client can be reassured that all is well. But I should stress yet again that mere signature on the last page is all that is absolutely needed. Even before the will is returned, it will then be valid should the worst happen, in what we all hope will be a short gap at that. What if no direct communication can be established, or perhaps only communication by telephone without any video with someone who is not a known client? In other words, you don't know their voice. Can anything at all be done there? Well, there are limits as to what a solicitor can help with in these circumstances, for reasons that the solicitor can't be sure of the client's identity, but also can't have any view in the person's capacity and whether they're being forced into make what they're being, as it were, told to sign in these circumstances. So it's not ideal. Certainly, a solicitor cannot, should not, take what I will call third-party instructions to make a will. Please make a will for my father. Here is exactly what he wants to do. Send me the will for signing, without at the very least being able to follow that up to get instructions by one of the methods mentioned above. And indeed, to get such indirect instructions might actually have warning bells ringing for the solicitor if somebody looks like they're attempting to make somebody else's will for them. However, there's nothing wrong at all in telling anybody that testator, somebody wishing to make a will, can write or type or have computer printed their own will or testamentary instructions. It can be confirmed because it's a simple legal truism that subscription alone, while not ideal, will create a valid testamentary instruction, and the law in creating a more formal document can also be given to the client if they wish to attempt that. I should stress this is not an encouragement, very much the opposite, towards the creation of homemade wills. If some of the things that I talked about earlier are possible, then that is a much preferable course of action. Homemade wills have generated much difficulty, and I will be absolutely frank with everybody on this. I have made a great deal of money over many years from people attempting to make their own wills and it not being clear what they meant, or not being clear how they've signed it, or not being clear that whether in fact what they're making is a will or just the preparatory stages of making a will. So it's not ideal. It's not ideal. But the point is that in our current extreme circumstances, it may be better to have this kind of limited thing in place than to have nothing at all. Moving to powers of attorney, much of what I've said can be applied equally to creating powers of attorney. There is, however, a significant difference in that in order for a power of attorney to be effective, if a person does lose their capacity, temporarily or permanently, then it needs to be registered with the Office of the Public Guardian. And in order for that to be done, it has to be certified either by a registered medical practitioner or a registered solicitor. Medical practitioners are very much busy with other things at the moment. I can't imagine they'll be, unless very readily available, that they'll be willing to undertake this. So how can it be done by a solicitor? Well, what it involves is the solicitor certifying that they have interviewed the grantor of the power immediately before the power is signed. So it can be prepared in the same way as we've talked about in relation to wills, in relation to getting wills witnessed. And then the solicitor can follow through with a video conference in order to have it signed by the client, see the client signing, and to carry out the interviewing instructions over video in the same way as if they were sitting across a desk. That is acceptable and will be acceptable in all circumstances. If it is then to be registered with the Office of the Public Guardian, and it can only be effective once it has been registered, then in this case, the signed power, after it has been seen by the solicitor over video screen, can be returned to the solicitor, who can make arrangements for registration. There may understandably be a bit more delay than is normally the case in registration taking place, although, as far as we're aware, procedures are in place for genuine emergency situations where people are really needing things done as quickly as possible. That need to return the document is perhaps in contrast in some cases to the position with wills, where it might be quite acceptable to leave it until things return to something like normal. And coming back to that something like normal, what should happen then? Well, clients should, and in some cases may have to, revisit what they've done during these strange conditions. As an extreme example, if all that they have is a valid, signed, and perhaps entirely self-created will, they will likely want that replaced by a fully formal version, Perhaps by that time, with more carefully thought out and indeed different provisions, when a solicitor can give advice as to what these provisions should be and take into account all kinds of other things that may not have occurred to the client as being relevant at that time. But in other cases, with full use of video technology and indeed the postal service, as I've discussed in the last 20 minutes, the full exercise may in fact already have been completed just as they need. And it may only be necessary to confirm that all is as it should be and that the documents are, by this stage, safely stored for a time that everybody hopes is a long time into the future. There's nothing good that's going to come out of all this, but the horrible stimulus to make sure that appropriate arrangements have been made for one's family and these very practical things for after death or after you lose capacity might be a small comfort for individuals and indeed for their families, and frankly, one less thing to worry about. Brodies is absolutely prepared for all that I have discussed with the appropriate facilities and, more importantly, the people available to deal with them just as much as required in these circumstances to make sure that it's done just as properly as possible. So please don't hesitate to contact us, to come to us in relation to yourselves or individual clients or indeed people that you might know that are anxious to have this done. We are absolutely geared up to do it and we'll be very happy to assist to the fullest extent that we can. Okay, that ends the formal part of what I wanted to say. What I now want to turn to is to just some potential things that might have been asked. One that has come in relation to that is questions of whether things can be done over the telephone. And the answer to that is generally not, though even that is not quite true in all circumstances. The position with the telephone is rather different. For a start, you cannot witness over the telephone. Witnessing is something that requires sight of the signature that is being witnessed. In other words, you need to see the physical act, you need to see the wet ink being applied in order for that to be effective. So the telephone doesn't cut it to that extent. There is a slight chance of that in certain circumstances, in relation to powers of attorney perhaps, not for witnessing but for certifying. If the client has recently met with the solicitor preparing the power of attorney and definitely knows their voice and makes such judgments as they can over a telephone interview, then it may be possible to actually get to the position where a power of attorney can be completed, even just by using the telephone. But generally speaking, then it certainly will not be possible to witness over the telephone, and it will, generally speaking, not be possible to certify, for example, for a new client who one has never met at all over the telephone either. So that is not one that I'm afraid can be followed through immediately at the moment. There are certain things that can be done over the telephone. For example, bits of instruction can be either clarified over the telephone and to some extent given over the telephone, but mere telephone without video facilities is not really ideal at the moment. So that is the one thing. Another question that has been put is a question in relation to can the same solicitor sign the certificate and also witness? The answer to that is generally yes. It is not preferred, but it is absolutely legal to do that. The same solicitor can be the witness and can also be the certifying solicitor. It's generally thought not to be ideal, but that is, I have to say, probably more of a personal view than anything else. I know that some entirely respectable and long-established solicitors think that is nonsense and there's absolutely no problem with doing it. And the clear thing is there's no legal problem with doing it. It will certainly not preclude the Office of the Public Guardian registering the document. There are many, many registered in that circumstance. So both witnessing and certifying can be done by video conference. Another question is just the second come in from Tracy Bissett, who wishes to know, can a power of attorney be submitted, I'm presuming for registration, without a witness? The answer to that is, I think, yes. Now, this, of course, is not something that has been explored to any great extent, but the power of attorney legislation does not in itself require a witness. Indeed, almost no documents in Scotland require a witness. What is required for witnessing is to make them effective in court proceedings. Now, with wills, court proceedings include commissary proceedings, include getting confirmation, and there may be an argument that powers of attorney are in the same kind of category. But I believe that technically a power of attorney does not require a separate witness. I confess I have not attempted to get one registered without a witness. I would rather hope that in the present circumstances, then it's possible that the Office of the Public Guardian would accept it in these circumstances. It's certainly better than nothing if a witness is not readily available, or indeed video conferencing is not readily available. Next question that has come in from Clifford George is, perhaps George Clifford, I'm not sure, perhaps you could expand on the limitations of power of attorney. There are in effect very few limitations on a power of attorney and what a power of attorney can do. In Scotland, since the year 2002, we've had two different versions, a continuing power of attorney, which deals with financial and property matters, and a welfare power of attorney, which, as the name implies, deals with much more personal matters. Now, the continuing one is in essence an area of long-standing before recent legislation, but powers of attorney have always been possible. And what continuing ones can do is limited really only by what you put in them. And the clear thing is that they should be expansive enough to cover anything that you might want to do, not just things that you know that you need to do at the moment. So as I say, they can be expanded to cover everything. There are certain things they can't do. For example, you can't delegate authority in a power of attorney that has already been delegated to you. To take the prime example of that is that if you are acting as a trustee, you, the trustee, cannot delegate that acting as a trustee to your attorney. Again, for the most part, there are certain items that could be done, for example, resigning as a trustee if it was explicit, but you cannot delegate things that have been delegated to you. But generally speaking, other things, pretty well everything, can be done by power of attorney. There's interesting and academic arguments, not for this time, for example, about whether people could even vote by power of attorney. I believe that they can't, but it's possible that that will be explored in future. One for perhaps, if this goes on for a while, long, deep the academic arguments in the dark nights, but for the moment, perhaps not an urgent one. Next thing is that we're asking a solicitor sign on behalf of someone unable to write or who is blind by video conference. The answer to that, I'm sorry to say, is thought to be no at the moment. The Law Society's guidance on this refers to the appropriate legislation requiring somebody to be in the presence of. Now, at the moment, the interpretation of in the presence of demands physical presence for notary public actings. I have a bit more doubt about that, I'm afraid, at the moment. I think that in the presence of, in the modern world, am I in your presence at the moment when I'm speaking to you here? And if I was able to see you as well, which I could readily do, then are we in each other's presence? Well, I think there's a decent argument that you are. But Law Society advice at the moment is that notary public actings, you actually need to be in the physical presence of in order to do that. Now, that could conceivably involve some kind of distanced presence, in other words, shouting out the details, which of course leads to other problems of confidentiality and that kind of thing. So that might be not ideal for other reasons. But at the moment, it is not reckoned that you can video conference notary public actings, therefore making a will for somebody unable to write or who is blind by that kind of thing. I personally hope that that changes. I think there are arguments to be had for that. It may be worth, if somebody is desperate to do this, with full warning as to the fact that it might not be accepted, it may be worth having a go if there is absolutely no other alternative available. But it is generally thought at the moment that you cannot, as it were, be physically remote in order to act as a notary public in these circumstances. Okay, that has taken us slightly beyond, a couple of minutes beyond the time that we had. I'm going to wind things up there. You will get, after this, in the fullness of time, a recorded version and an invitation and contact details. If there's anything else that people need to follow up on, then please feel free to do so. I will do my very best to answer them as and when they are received, particularly if you have got people who wish to follow up on this and get things done, then we're very much in a position to do so, and we'll be glad to assist in these circumstances. Thank you all very much for attending. I'm very grateful that you've taken time out of your morning to do so. We may repeat this exercise later, but at the moment, thanks very much and good morning to you. Bye, folks.